And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I'm your host, a disembodied voice represented by an icon with cool little concentric circles around it, showing when I'm speaking. The sun is currently trying to eat Uncivil Law, where the sun is positioned, peeking through my blinds, just so it is currently trying to eat me alive. So we are doing an anti-face reveal, wherein you get to look at the beauty that is my icon, surrounded by all the voice goodness that it has to bring. Very, very exciting. And if the stream is extremely popular, maybe I'll just never be on camera ever again. Because, I mean, that's really hard. We could just do audio. Or maybe I could become a VTuber. That could be fun. We could get some sort of justice-based avatar or something, and we dock that way. That'd be good. I don't know. These are some possibilities that present themselves. But for the moment, we're here to talk about this case from the Fifth Circuit, which deals with possession of a person with a domestic restraining order of a firearm, which is illegal under federal law. Or is it? Because maybe the federal law itself is illegal, unconstitutional. And we have a decision from the Court of Appeals for the Fifth Circuit coming out of Texas, trying to decide this very issue as we speak, dealing with these things. So we're going to read this decision and go through the analysis and try to understand it and dissect it and try to see what we think about it. Is it good? Is it bad? Does it track the legal decision? Does it track the Constitution? All that good stuff. So this is United States of America versus Zachary Rami. Not Zachary, Zaki. I'm not sure what Zaki means or what the origin is, but that's the guy's name, Zaki. All right, so we are in the Fifth Circuit at a Texas Court of Appeals, and the question presented in this case is not whether prohibiting the possession of firearms by someone subject to a domestic violence restraining order is a laudable policy goal. Our immediate problem isn't whether or not it's good. That is not our immediate issue. The immediate issue is whether 18 U.S.C. 922 G8, a specific statute that does so, is constitutional. I will take note here that at least we can understand this to be dealing with the specific statute. So this doesn't necessarily mean that all statutes that strip people that are guilty of domestic violence or suspected of domestic violence are unconstitutional, because, of course, we could get into the specific wording of any specific statute. So it may turn, well, it's going to turn on some degree necessarily. It's going to turn necessarily, at least to some degree, on the wording. And so the question is how narrow or not this decision is. How close does this wording, or how broad is this principle? So that's one of the issues we can say. So right away, we note that we're dealing with 922 G8, a federal statute that deals with federal disqualification and its specific things, which isn't necessarily to say, at least on first and blush, that Congress couldn't write some other statute that would deal with this in some other way. Then the Fifth Circuit continues by saying, in light of Bruen, that this decision is not constitutional. Zaki Rami levies a facial challenge to 922 G8, which would mean that it is illegal, not necessarily as to him in particular, but as to all people. The statute is on its face defective. The district court and a prior panel upheld the statute, applying this court's pre-Bruen precedent. Rami filed a petition for rehearing en banc. While the petition was pending, the Supreme Court decided Bruen. The prior panel withdrew its opinion and requested supplemental briefing on the impact of the case on this one. So they had already said, no, not so much with the domestic violence and possession thing. We've already decided this issue. You're asking for an en banc. While that's pending, while the case is still pending, the Supreme Court decides Bruen. So the panel that had decided this case said, you know what? Let's take another look at it. And so they vacate their own decision, which is something a court can do. They vacate their own decision, and it's like, we'd like further supplemental briefing. Fine. Considering the issue afresh, we conclude that Bruen requires us to reevaluate our Second Amendment jurisprudence, and under Bruen, 922 G8 fails to pass constitutional muster. We therefore reverse the district court's ruling to the contrary and vacate the conviction. All right, let's read more. Between December 2020 and January 2021, Ramini was involved in 5 shootings in and around Arlington, Texas. That's probably bad. If you're involved in 5 shootings, something has gone wrong on some level. On December the 1st, after selling narcotics to an individual, he fired multiple shots into that individual's residence. Please don't do that. The following day, Raimi was involved in a car accident. He exited his vehicle, shot at the other driver, and fled the scene. I'm guessing this guy has some temper issues and should be charged with many things. I'm seeing some problems. If we're looking for crimes to charge him with, I'm not running really short on things to charge him with. Firing shots into individual residents, firing shots at the other driver's car, presumably with the driver in it. Well, attempted murder comes right to mind. Also, if you're shooting from a car, you got that drive-by stuff, so that's always fun. On December 26th, Ramini shot at a police vehicle. On January 7th, Ramini fired multiple shots into the air after his friend's credit card was declined at Whataburger. Guys, shooting into the air because your credit card was declined is not the way to go through life. So if we're trying to say, is he a bad guy? I think the answer is yes. If we're trying to say, is he guilty of many, many things? I think the answer is yes. We have many, many problems. So we can charge him with many, many things. Also, depending on exactly when he shot into the air relative to the credit card decline, relative to the time frame, it could even be like attempted robbery. It could be like an armed robbery, like basically give me the Whataburger or else. I think Whataburger is okay. I'm not sure it is let's go to prison for it worthy, but that's just me. All right. Officers in Arlington Police Department identified Raimi as a suspect in the shootings and obtained a warrant to search his home. Officers executed the warrant and found a rifle and pistol. Raimi admitted that he possessed the firearms. He also admitted he was subject to an agreed civil protection order entered on February the 5th, 2020 by a Texas state court after Ramini's alleged assault of an ex-girlfriend. The protective order restrained him from harassing, stalking, or threatening his ex-girlfriend and their child, and also expressly prohibited Raimi from possessing a firearm. A federal grand jury indicted him for possessing a firearm while under a domestic violence restraining order in violation of law. I, again, just wish to emphasize, for the sake of absolute clarity, that this does not mean we can't charge him with many, many other things. Many, many other things. Even federally, we might be able to charge him with other things, right? The question isn't, can't we charge him with many things? The question is, can we, at least at the moment, can we charge him with this specific thing? Let's take a drink every time Kurt comes up with a new way to say his name. That is a dangerous proposition, my friend. I wouldn't necessarily recommend it. So we are charging him, Raimi, with possession of a firearm while under a domestic violence restraining order in violation of 18 U.S.C. 922 G8, which provides that it shall be unlawful for any person who is subject to a court order that was issued after a hearing of which such person received actual notice and which such person had an opportunity to participate, restrains such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child, and includes a finding that such person represents a credible threat to physical safety of such intimate partner or child, or by its terms expressly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury to, finally, the thing that is actually making it the thing that you can't do, possess in or affecting commerce any firearm or ammunition. And we know that just means possessing firearms and ammunition, because good luck with it not affecting commerce, because we know how deep that goes. So basically, if you have had an opportunity to be heard before a court and they say you're a threat and not to possess the firearms, then not possess the firearms. That is the federal statute in so many words. Rahimi moves to dismiss the indictment on the ground that G8 is unconstitutional, but acknowledges that a prior decision from this court forecloses argument. The district court, of course, denied the motion and pled guilty because the district court is, of course, bound by the precedent. So the district court is quite right. On appeal, Rahimi renewed his constitutional challenge. Rahimi again acknowledged his argument was foreclosed, and the prior panel agreed. When you have a court, when you have a circuit court, a circuit court is bound by its own precedent. So on appeal, they're going to say, well, you know, the precedent is this, we can't change it. But someone else can change it. Who else can change? Who can change precedent? Well, the en banc or the Supreme Court. After Bruen, the prior panel withdrew its opinion, ordered supplemental briefing, and ordered the court to expedite the case for oral argument before another panel of the court. Rahimi now contends that Bruen overrules our precedent, and under Bruen, it's unconstitutional, we agree. So the panel says, first and foremost, Bruen overrules our precedent. We are, of course, bound by the Supreme Court more than we're bound by ourselves. So we got to kind of do that. So first, let's deal with the precedent and all the rest of that thing. Under the rule of orderliness, one panel of the Fifth Circuit may not overturn another panel's decision, absent intervening change in law, such as by statutory amendment, or by the Supreme Court, or en banc. So when you go to appeal, the appellate panel is bound by its own precedent. So one panel binds another. If you want to change the panel's decision, only the en banc court can do that, or of course the Supreme Court, because they outrule them, or to the extent it's statute, the statute overrules them. So those are the ways to do it. One panel cannot just change another panel's mind. That's not how that works. The Supreme Court need not expressly overrule our precedent. Rather, a latter panel must simply determine a former panel's decision has fallen unequivocally out of step with some intervening change in law. One situation in which this might naturally occur is where an intervening Supreme Court decision fundamentally changes the focus of relevant analysis. That is the case here, as the government concedes. So it appears that the government agrees that the Supreme Court has overruled the Fifth Circuit. What is en banc? When you go to federal appeal, the entire appellate court doesn't hear the case. A panel hears it. It's a panel of 3 people. The total number of judges that sits on each appeal court varies by the panel, varies by the circuit. In the Ninth Circuit, I believe it is 23 judges who sit on the Ninth Circuit, and they are the biggest of the group, both geographically, by population, and by the number of judges. Different circuits have different numbers. So the en banc is where the entire Fifth Circuit for this case would sit on it. So rather than the 3-judge panel, how about all of them? How about like 11 of them, or whatever the number is in the case of the Fifth Circuit? So, you know, that's how that rolls. A panel is bound by a previous panel, and only all the judges can overrule themselves. That's how that goes. All right. In Emerson, we held the Second Amendment guarantees an individual right to keep and bear arms. The First Circuit expressly to do so. The Fifth Circuit has been pretty good about these issues, all things considered. But we also concluded that G8 was constitutional as applied to the defendant there. As applied. All right. Emerson first considered the scope of the Second Amendment right as historically understood, and then determined, presumably by applying some form of means and scrutiny, sub silentio, which is basically a way of saying without saying it. That's literally what it means. In silence, right? That's why they say presumably by applying, because the court didn't say. So they say presumably by applying sub silentio because the court must have done it, even though it never said it. So they did the historical analysis, and then without saying that they were doing it, apparently did some sort of means and scrutiny by saying narrowly tailored to the goal of minimizing the threat of lawless violence. This has been the overall trend of the circuit courts on the Second Amendment issue. And unfortunately, it's always a compelling governmental interest. And so basically you just wind up into, is it narrowly tailored? And well, the answer to that is almost inevitably yes, at least the way the courts of appeal have been dealing with the issue. Jennifer says all 23 they'll never agree. You don't have to get them all to agree. You just have, they all hear the case. They don't all agree. That just means they all hear the case. If you have the entire en banc, all the judges sit and hear the case. Whatever the vote is, the vote's the vote. And in the case of the Ninth Circuit, they don't even all hear because it's so many. They only have a group of 12, and they say that's everyone when it's totally not. But they pretend it is. Or 13 or whatever the number is. But yeah, so if you have 11 members of the court sit, then you just need 6 votes. So you don't need them all. Although occasionally you get unanimous decisions. You get unanimous decisions out of the Supreme Court. I mean, they have 9 people and they get unanimous decisions more than half the time. So, you know, it's not that bad. So anyways, carrying on. After DC versus Heller, courts coalesced around a similar 2-step inquiry for analyzing laws that might impact the Second Amendment. First, we asked where the conduct at issue fell within the scope of the Second Amendment right. If it fell outside of it, then it's constitutional, which is a perfectly reasonable thing to think. Because this is something I've talked to you guys a lot about before, right? What is the scope of the Second Amendment? So if it's not within the scope of the Second Amendment, then we can stop talking, right? It might involve guns. It must be true, in my opinion. It must be true that it can involve guns but not involve the Second Amendment. In the same way that it's possible for it to be words but not involve the First Amendment. And we have plenty of examples like that when it comes to, for example, like, you know, defamation or obscenity or things like that, right? There are things that are outside the scope. So it must be possible that we are talking about guns or other kinds of arms, but not talking about the Second Amendment. So that would be a possibility. If conduct fell outside the scope of the Second Amendment, then the challenge law was constitutional. But if conduct fell within the scope of the right, we then proceed to the second step of the analysis, which either applies intermediate or strict scrutiny. In McGinnis, this court upheld this using a 2-step framework. The initial panel in this case did likewise, citing McGinnis. All right, so basically at this point, we're just talking about how we did things in the long ago in the far, far away, which was before Bruen. Before Bruen, we asked, is it within the Second Amendment? If so, if not, then we're done. Great. And one of the ways we might ask that question, at least in part, is by historical analysis. So all those things. So we're considering all the things there in terms of the historical analysis. But then after that, we went on to a step 2. We went to the step 2 about narrowly tailored. But the Supreme Court says no. So enters Bruen, expounding on how the Supreme Court held that when the Second Amendment plain text covers an individual conduct, the Constitution presumptively protects the conduct. In that context, the government bears the burden of justifying its regulation by demonstrating that's consistent with the nation's historical tradition of firearms regulation. Put another way, the government must affirmatively prove that firearms regulation is part of historical tradition that delineates the outer bounds of the right to keep and bear arms. So this is one way of thinking about this, if you like. So there's a couple ways to go about thinking about this. We can think about this as, if we're thinking about defamation, or we're thinking about slander and libel, fighting words, obscenity. If we're thinking about that kind of thing, we can either say to ourselves, well, it's categorically excluded from the First Amendment right, so it's not within the scope of the First Amendment right at all. That's one way to think about it, and I think probably on balance the better way to think about it. Another way we can go about it is by saying, well, the Constitution says speech, so it must include all speech unless you can show through history it doesn't, which kind of gets you to the exact same place in the end. because we've already mapped out these boundary lines. So maybe it's just a different way of looking at the exact same thing. Maybe there's really no difference in the end between the two. Like either way, the question you're asking is, what are the boundaries of, for example, the freedom of speech? What are the boundaries? And looking to history and tradition is the best and proper way of understanding what that means. What did it mean when they wrote those words? What is the right to speak? What is the freedom of religion? What is the right of assembly? What is it? Right? And the way to understand that is by history. And so same too with firearms. So maybe it's just a different way of looking at the same exact thing, and there's really no difference in the end, but I'll simply note there's a potential difference, and we'll press on. In course of explication, the court expressly repudiated the circuit court's means and scrutiny, the second step embodied in Emerson and applied in McGinnis. To the extent the Supreme Court did not overtly overrule Emerson and McGinnis, it did not cite those cases, but discussed other circuits' similar precedent. Bruen clearly fundamentally changes our analysis in a way that implicates the Second Amendment, rendering our prior precedent obsolete. I think this is probably true, and the government seems to concede it. And so the panel's like, well, we're not bound by ourselves because the Supreme Court overruled us implicitly. And so, we got to do that now. All right, so having decided that, our law has vanished into nothing burger, therefore, our review of Raimi's facial challenge is de novo, which is just from the beginning. Very from the beginning, as it turns out, because, we just wiped our precedent off the book. First, the court addresses the government's arguments that Raimi is not among those citizens entitled to Second Amendment protection. What? No. I don't think that quite works, but okay. Concluding he is, we then turn on to whether G8 passed Bruen. According to the government, Heller and Bruen add a gloss on the Second Amendment that restricts its applicability to only law-abiding responsible citizens. That kind of assumes the thing you're trying to prove. Even if that were true, you're assuming the very thing you're trying to prove. Like, it doesn't apply to him because he's not law-abiding, and he's not law-abiding because he didn't follow the statute. And the statute is legal because it's bound by the Second Amendment. And around we go. Because Raimi is neither responsible nor law-abiding, as evidenced by conduct, there's some, to give the government's due, and they're not completely without merit on that, right? As evidenced by his conduct and by domestic violence restraining order against him, he falls outside the ambit of the Second Amendment. Therefore, the government argues his constitutional laws applies to him. There is some debate on this issue. As summarized by now Justice Barrett, one approach uses history and tradition to identify the scope of the right, and the other uses the same body of evidence to identify the scope of the legislature's power to take it away. So maybe those are the same thing in the end, or maybe not. Maybe there is a difference between those. Maybe it's like a positive versus negative way of looking at it. Like if you're trying to draw the boundaries of a piece of land, you can obviously say this is within the piece of land, or you can say this is outside the piece of land, right? So maybe they're ultimately the same, but maybe there's a difference. The government argues that Raimi falls outside the community covered by the Second Amendment rest on first approach. The sun is eating my face. It's really bad. I just want to say. Yeah. The government's argument that Raimi falls outside the scope of the community covered by the Second Amendment rests on the first approach, but runs headlong into Heller and Bruen, which we read to espouse the second one. Unpacking the issue. Turning the blind the other way won't help. It's coming through the gap in the blinds for the cords. It's coming through the very narrow gap in the blinds for the cords. So turning the blind the other way won't help. I'm being eaten through a very, very narrow slit in the blinds for strings. String holes are eating my face. Unpacking the issue. The government argues that because it's inconsistent with Heller, Bruen, and the text of the Second Amendment, it inexplicably treats Second Amendment rights differently than other individually held rights and has no limiting principles. The no limiting principles thing is a real problem, by the way. When you can't find limiting principles, have I tried turning off the sun? I was thinking about turning off the sun in about an hour and a half. So, I late soon. The Second Amendment provides simply enough. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Heller explained the words "the people." Excuse me. Okay, I'm still alive. Heller explained the words "the people" in the Second Amendment have been interpreted throughout the Constitution to unambiguously refer to all members of the political community, not an unspecified subset. I mean, that would have to be true. It would have to be the same thing that would be true for like the rest of the Constitution. Furthermore, the people referred to a class of persons who are part of a national community or otherwise develop sufficient connection with this country to be considered part of the community, citing Verdago Urquidez, which is definitely the dominant opinion on what the people means. That is definitely the case to cite. For those reasons, the Heller Court began its analysis with a strong presumption. The Second Amendment right is exercised individually and belongs to all Americans, and then confirmed that presumption. Heller's exposition of the people strongly indicates that Raimi is included in the people. To be sure, as the government argues, Heller and Bruen also refer to law-abiding responsible citizens in discussing the amendment's reach. But read in context, the court's phrasing does not add an implied gloss that constricts the Second Amendment reach. Heller simply uses the phrase law-abiding responsible citizens as shorthand in explaining that its holding, the amendment confines an individual right to keep and bear arms, should not be taken to cast doubt on long-standing prohibitions on possession of firearms by felons and the mentally ill, or laws forbidding carrying of firearms in sensitive places such as schools and governmental buildings. As always, I'll just simply note, again, I know the corner box is covering some of the text. The corner box is my avatar, and all the text I'm reading should be on screen. Hopefully nothing I'm reading will be covered by the box. The box is my representative at the moment, and the box is awesome. All hail the box. Yee. Okay, carrying on. In other words, Heller's reference to law-abiding responsible citizens meant to exclude from the court's discussion groups that have historically stripped of Second Amendment rights. Bruen's reference to order. How am I doing on the stream, incidentally? 200 people watching the box. Outstanding. The government's reading of Heller and Bruen also turns the typical way of conceptualizing rights on its head. A person could be in one day and out the next. The moment he was convicted of violent crime or suffered the onset of mental illness, his rights would be stripped as self-executing consequence of his new status. Yeah, that's a real problem. That is a real problem. I see further criticisms of the box. The box will not be deterred. This is an unusual way of thinking about rights because in other contexts that involve the loss of rights, the deprivation occurs because of state action, and state action determines the scope of the loss, subject, of course, to any applicable constitutional constraints. Felon voting rights are a good example. A state can disenfranchise felons, but if it refrains from doing so, their voting rights remain constitutionally protected. The government fails to justify this disparate treatment of the Second Amendment. Yeah, that's a real problem. That's a real problem. You can't treat the Second Amendment different. We've been trying to treat the Second Amendment different than the other amendments for quite some time. And really, Emery, the box is the thing that's going to cause you to leave? Wow, I'm feeling unloved. Particularly since all the text I'm reading is not covered by the box. Wow. I feel so unloved. Lame. Perhaps most importantly, the government's proffered interpretation lacks any true limiting principle. Why am I talking? You didn't come here for commentary? Perhaps most importantly, the government's proffered interpretation lacks any true limiting principle. Under the government's reading, Congress could remove unordinary or irresponsible or non-law abiding people, however expediently defined, from the scope of the Second Amendment. Could speeders be stripped of the right to keep and bear arms? Political nonconformists, people who do not recycle or drive an electric vehicle. That's a pretty good one right there. One easily gets the point. Neither Heller nor Bruen condenses such a malleable scope of the Second Amendment protection. To the contrary, the Supreme Court has made clear that the Second Amendment right is exercised individually and belongs to all Americans. Raimi, while hardly a model citizen, yeah, that's definitely one way of putting it, is nonetheless part of the political community entitled to Second Amendment protections. Tim West donates $5 to say the box is objectively true and good. That's right. The box, for sure, is protected by our Second Amendment rights and also our First Amendment rights. The box is using its freedom of speech to cover some of the other text because it wants to be represented that way. And you're suppressing the box's First Amendment rights by suggesting it move. Which brings us to the question of whether Raimi's right to keep and bear arms could be constitutionally restricted by operation of G8. The parties dispute Raimi's burden necessary to sustain the facial challenge to the statute. The government contends that Raimi must establish that no set of circumstances under which the act would be valid. That is typically true for a facial challenge. Raimi contests the assertion asserted during oral argument that the government's interpretation of Salerno has fallen out of favor, though he contends that in any event, he has satisfied the standard. Bruen instructs us how to proceed. Oh joy, a court actually looking at the Supreme Court for guidance. What a novel concept. The plaintiff there levied a facial challenge to New York's public carrying legislation. To evaluate the challenged law, the Supreme Court employed a historical analysis aimed at assessing whether modern firearm regulations are consistent with Second Amendment text and historical understanding. Construing Heller, this court flatly rejected any means and scrutiny as part of the analysis, such that if the statute is consistent with the Second Amendment, the text, historical, and understanding, it falls under any set of circumstances. Okay, guys, I know that you've enjoyed the box for some time, but the sun has finally moved. Thank God. It has finally moved across my eyes, and my eyes are now allowed to look at things again. So I'm going to put my face back on screen. Damn it. Whatever. All right. Also, you get to enjoy the magic that is my new haircut. Are you ready for new haircut reveal? Are you ready for new haircut reveal? Are you ready for the unboxing of the haircut? Is your soul prepared? Okay, here we go. All right, there we go. Oh, looking sharp, I think. Looking sharp, my friends. Nice. Yeah, not bad. Not bad. All right. Let's return to the text. The box is now sexier by some margin. You're looking good. Thank you, Dawn. I appreciate that. I really do. Bruen articulated two analytical steps. First, the court must determine whether the Second Amendment's plain text covers an individual's conduct. If so, the Constitution presumptively protects that conduct. If so, okay, and the government must justify its regulation by demonstrating it's consistent with the nation's historical traditions. Only then may a court conclude that an individual conduct falls outside the Second Amendment. That does seem to be what the Supreme Court asked the lower courts to do, and the Fifth Circuit is actually trying to do it. I'm amazed. It's an amazing concept. To carry its burden. The tech crisis says $20. I'm way behind, but think the VTuber thing would be funny as a goof. Should you give it a shot? The only way it would be funny is if I downloaded some sort of like basic ass like anime avatar or something and made that work. That would be kind of funny. Excuse me. You also have to say, "What's up? It's your boy, Uncivil Law, here with another's decision." Boys! To carry its burden, the government must point to historical precedent from before, during, and even after the founding that evinces a comparable tradition of regulation. We are not obligated to sift through historical material for evidence to sustain it. That's the government's burden. Well, thank God for making it the government's problem. That's really good. To me, I look the same. I'll just take that to mean that I'm always handsome in your eyes. Is this an argument for restoring gun rights to those convicted of misdemeanor DV crimes? We're reading. I'll let you know. The government need not identify a historical twin. Rather, a well-established and representative historical analog suffices. This makes sense. This would be how we treat a First Amendment analysis too, right? This would be the same thing as a First Amendment analysis, right? What is the twin for, I don't know, Twitter? In history, not much. But what's the analog? Many things, right? Gossip columns, maybe. But there's analogs for sure. We are reading a Fifth Circuit decision on the right to keep and bear arms, as it may or may not relate to people who have done some things of improper scope in domestic arena. The Supreme Court distills two metrics for courts to compare government's proffered analogs against the challenge law: how the challenge law burns the right to armed self-defense, and why the law burns the right. Whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and whether that burden is comparably justified, are essential considerations when engaging in the analytical inquiry. As to the degree of similarity required, analogical reasoning. As to degree of similarity required, analytical reasoning under the Second Amendment is neither a regulatory straitjacket nor a regulatory blank check. Courts should not uphold every modern law that remotely resembles a historical analog, because doing so risks endorsing outliers that our ancestors would never have accepted. On the other hand, even if modern day regulations are not a dead ringer for historical precursors, it still may be analogous enough to pass constitutional muster. The core question is whether the challenge law and proffered analog are relevantly similar. And again, I think here you're doing the same kind of thing you do in a First Amendment analysis. I think this is basically the same in the First Amendment analysis. So as you're considering how you may or may not regulate social media or even television, radio, whatever, this is the same kind of thing you do in a First Amendment analysis. What are the historical analogs? And how do you reason from that? I think this is fundamentally right the same thing. Thank you very much, Eric. I appreciate your kind chat. Got a haircut, which helped a lot. And yeah. Whether a challenge regulation addresses a general societal problem that's persisted since the 18th century, the lack of distinctively similar historical regulation addressing the problem is relevant evidence that challenge regulation is inconsistent with the Second Amendment. Moreover, if earlier generations addressed the societal problem, but did so through materially different means, that also could be evidence that modern regulation is unconstitutional. Again, this sounds pretty analogous to how we would reason in a First Amendment reading. Before I get to the court's rule, what would my idea on the ruling be? Well, I'd want to know, without reading more, I'd want to know what the government's evidence is of historical analogs to G8. That would be my first pertinent question. If there are none, then the regulation must be unconstitutional. If there are some that are argued, the degree would be how close they are or not. So I would want to know what the government thinks are the historical analogs. Kurt, name me one other right that specifically said could not be abridged. We've had this discussion many times, but I suppose we can have it one more time. Shall not be infringed. Infringed, by the way, not abridged. So I guess I'll answer that question that way. Name me one other right that specifically states cannot be abridged. There are no constitutional rights that say shall not be abridged. I hope that answers your question. Raimi's possession of a pistol and rifle easily falls within the purview of the Second Amendment. The amendment grants him the right to keep firearms, and possession is included within the meaning of keep. And it's undisputed that the type of firearms that Raimi possesses are in common use, such that they fall within the scope of the amendment. The Second Amendment protects only the carrying of weapons that are in common use at the time, as opposed to those that are highly unusual in the society at large, citing Heller. Thus, Bruin's first step is met, and the Second Amendment presumptively protects Raimi's right to keep the weapons officers discovered at his home. But Raimi, like any other citizen, may forfeit his Second Amendment rights if his conduct ran afoul of lawful regulatory measures prohibiting the possession of firearms. That's consistent, and this is the key in both the Second Amendment and the First Amendment, that's consistent with historical tradition that delineates the outer bounds of the rights to keep and bear arms. That's the key. What are the bounds? That's the first question. What are the bounds? The question, therefore, turns on whether G8 falls within the tradition or outside of it. To reiterate, the statute says what we read before. Distilled to its essence, the provision operates to deprive an individual of the right to keep and bear arms once a court finds, after notice and hearing, the individual poses a credible threat to an intimate partner or her child and enters a restraining order to that effect. The covered individual forfeits his Second Amendment right for the duration of the order. This is so even when the individual has not been criminally convicted of any offense and where the underlying proceeding is merely civil in nature. These characteristics crystallize how and why G8 burdens a law-abiding citizen's right of self-defense. In particular, we focus on keys of the statute. Forfeiture of the right to possess weapons after a civil proceeding in which the court enters a protective order based on finding of credible threat in order to protect that person from domestic gun abuse. The first three aspects go to how the statute accomplishes its goal. The fourth is the statute's goal, the why. To satisfy the burden on Raimi's Second Amendment right, the government bears the burden of proffering relevantly similar historical regulations that imposed comparable burden on the right of armed self-defense that were also comparably justified. And while it comes to interpreting the Constitution, not all history is created equal. Constitutional rights are enshrined within the scope they were understood to have when the people adopted them. Damn right. Damn right. The question is, what does the Second Amendment mean when it was written? So not all history is particularly informative to that, particularly history that follows that time as you get more and more separated from it. So contemporaneous actions are probably more informative than more distant ones. And the Supreme Court basically said that as well in Bruen. The government offers potential historical analogs. Okay, let's see what you got, government. English and American laws and sundry unadopted proposals to modify the Second Amendment. Lol. The unadopted proposals to modify the Second Amendment mean F all to me because, people can propose anything. So I don't care. Providing for disarmament of dangerous persons, English and American going armed laws, and colonial and early state surety laws, which is insurance. We discuss in turn why each of these historical regulations falter as relevantly similar. The government relies on laws of varying antiquity as evidence of dangerousness analogs. We sketch these chronologically, mindful that greater weight attaches to laws nearer to the time of the Second Amendment ratification. This is consistent with what the Supreme Court said in Bruen. The Supreme Court also said that things that are closer to the time of ratification are more likely than their more ancient counterparts. Under the English Militia Act of 1662, officers of the Crown could seize all arms in custody or possession of any person whom they judged dangerous to the peace of the kingdom. Citing scholarship, the government thus posits that by the time of the American independence, England had already established a well-practiced tradition of disarming dangerous persons, violent persons, and disaffected persons perceived as threatening to the crown. Stacy Walpole gives $5 in super chat to say, when my son passed in Houston, 2014, Ellie took all of his firearms, no crime. The only reason we got them back was by using assist from Ellie friends. I'm glad you were able to secure your property back. The police have an unfortunate tendency of seizing property that doesn't belong to them. And sometimes they get busted for it. I recently saw a tape of police officers describing finding money and then how they were going to split the money illegally. So thanks to cameras and such, more and more of these are coming to light. So I'm glad you were able to get your stuff back. That's really good. The Militia Act's provenance demonstrates it's not a forerunner of our nation's historical tradition. Under Charles I, the Crown and Parliament contested for control of the militia. After the resulting civil war and Oliver Cromwell's interregnum, the monarchy was restored in 1660 when Charles II took the throne. Charles II began using the militia to disarm his political opponents. The Militia Act of 1662 facilitated this disarmament, which escalated under Catholic James II once he took the throne in 1685. After the Glorious Revolution, which enthroned Protestants William and Mary, the Declaration of Rights, codified as 1689 English Bill of Rights, qualified the Militia Act by guaranteeing that all subjects which are Protestants may have arms for their defense suitable to conditions as allowed for by law. This right, which restricted the Militia Act's reach in order to prevent the kind of politically motivated disarmaments pursued by Charles II and James II, has long been understood to be the predecessor to our Second Amendment. This understanding and the history behind it defeats any utility of the Militia Act of 1662 as a historical analog. So basically, the Militia Act of 1662 was the very reason the predecessor for the Second Amendment was created. So probably not what the Second Amendment means, because the Second Amendment's predecessor was a reaction to this abuse. That's basically what the Fifth Circuit is arguing. The government next points to laws in several colonies and states that disarmed classes of people considered to be dangerous, specifically including those unwilling to take oath of allegiance, slaves, and Native Americans. These laws disarmed people thought to pose a threat to security of the state due to their lack of perceived loyalties on societal status. How many people are watching right now? 207? That's not too bad. I appreciate that you were here, by the way. While public safety was a concern, most disarmament efforts were meant to prevent armed rebellions. The early Americans adopted much of the tradition in the colonies. I'm going to have to also record at some point a more abbreviated version of this as an edited video, because this is pretty good stuff, but it's not really suitable for, so I'm going to have to paraphrase a lot of this or something and doing something. Excuse me 1 second. Shiori, I think we will do the other case another time. I don't think we'll do it back to back, but I've been enjoying this quite a lot. Unless we get enough people watching and demanding it. Maybe if we hit some sort of metric, we can do it, but I think it's probably best served another time. Finally, the government offers 2 proposals that emerged in state ratifications conventions, considering the proposed constitution. A minority of Pennsylvania's convention authored a report in which they contended that citizens have a right to bear arms unless for crimes committed or real danger of public injury. At the Massachusetts Convention, Samuel Adams proposed a qualifier to the Second Amendment that limited the scope of the right to peaceable citizens. But these proposed amendments are not reflective of the nation's early understanding of the scope of the right. While they were influential proposals, neither became part of the Second Amendment as ratified. Thus, the proposals might somewhat illustrate the scope of firearms rights at the time of ratification, but they cannot counter the Second Amendment's text or serve as an analog for G8 because, among other things, they were not enacted. And the very fact that they were trying to enact them suggests the Second Amendment didn't already include them. Because why would they enact them if the Second Amendment already included them, right? So it's suggestive that it's not already there. Brief aside, and we can have a poll on it about, and this poll will in absolutely no way be binding, but I'm interested in your perspectives on continuing to cover the Murdaugh case. We've been doing it for 2 weeks, and I found it extremely frustrating and also somewhat taxing because I've been on camera by myself pretty much the entire time with some minor exceptions. But for the vast majority of the time, I've been on by myself, and I don't know that it's very interesting, at least for me. So I think I'm going to give up. But I'm interested in what your views are on the issue. So I guess the poll question would be, should I continue Murdaugh coverage? And we'll see what you guys say, which I then may ignore completely. Can I do a recap stream? To do a recap stream, I'd have to watch it or read news articles about it, but maybe. Maybe do closing arguments? Maybe. The government also relies on ancient criminal offense of going armed to terrify the king's subjects. This common law offense persisted in America and was in some cases codified. The government offers 4 exemplars codified in Massachusetts Bay Colony, the state of Virginia. Are you sure you don't mean Commonwealth? And colonies in New Hampshire and North Carolina. The Massachusetts law provided that every justice of the peace may cause to be stayed and arrested all affrayers, rioters, disturbers, or breakers of the peace, and as such shall ride or go armed defensively, and upon view of such justice or justices, confession of the party, or other legal conviction of any such offense, shall commit the offender to prison and seize and take away his armor or weapons. Similarly, the New Hampshire statute authorizes justice of the peace, upon view of such justice, confession of the party, or legal proof of any offense, to cause the offender's arms or weapons to be taken away. You think the Murdaugh trial could be a good way to build my following? I don't know that it's not. I don't know that it's really accomplished that objective in the last 2 weeks, to be honest. I don't think we are really growing very substantially. Did I do a deep dive into Alex Murdaugh before I started? Not a deep dive, no. But I definitely did some stuff concerning the case beforehand. I didn't want to do a super deep dive because I wanted to learn what I'd learned from the case. The growth will all come in at the end. On what basis do you draw that conclusion? Virginia's law differed slightly. No man shall go or ride armed by day or by night, in fairs or markets or other places, in terror of the country, upon pain of being arrested and committed to prison by any justice on his view, or proof of others, there to a time for so long as time as a jury, to be sworn in for that purpose by said justice, shall direct, and in like manner to forfeit his armor of the Commonwealth. North Carolina colonial law was contained within constable's oath, which required constables to arrest all such persons as in your sight shall riot or go armed offensively, or shall commit or make any riot, affray, or other breach of the peace. While similarly aimed at curbing going armed offensively, North Carolina law did not provide for forfeiture. Yeah. You get better exposure from my channel going on other shows that are covering it. I'm not sure that's necessarily true or not. I'm not sure how much further exposure there is for me to be gained by appearing as a panelist on other people's shows at this point. These proffered analogs fall short for several reasons. An overarching one is the dubious going armed laws are reflective of our nation's historical tradition of firearms regulation, at least as to forfeiture of firearms. North Carolina law did not provide for forfeiture, so it quickly falls out of the mix. And fairly on, Massachusetts and Virginia dropped forfeiture as a penalty, going the way of North Carolina, and thereby undercutting government's reliance on these laws. Indeed, Massachusetts amended its law to remove forfeiture provision in 1795, just 4 years after ratification of the Second Amendment. Yeah, I might just take some time off. Tag team with someone? It's not a bad idea if I could find someone to tag team with. It's unclear how long New Hampshire's going armed law preserved its forfeiture provision, but assuming argument it persisted longer than others, one outlier is not enough to show a tradition of public carry regulation. And on substance, the early going armed laws that led weapons forfeiture are not relevantly similar to G8. First, those laws only disarmed an offender after criminal proceeding and conviction. Moreover, the going armed laws, like the dangerous laws possessed above, appear to be aimed at curbing terroristic or riotous behavior, disarming those who have been identified, adjudicated to be a threat to society generally, rather than identified individuals. Well, I'm not sure the degree to which that's true or not, to be quite honest. I'd have to really consider it, but it's a little bit, I'm not sure if I agree with that rationale, to be quite honest. Legal Mindset's already tag teaming with Vices. And Legal Mindset also said he was thinking about bailing out on it too for similar reasons. Ian, I can ask, send out a note. You prefer my case review to trial coverage? Lastly, the government points out to historical surety laws. At common law, any individual who can show they had just cause to fear another would injure him or destroy his property could demand surety of the peace against the person. The surety was intended merely for prevention, without any crime actually committed by the party, but arising only from probable suspicion that some crime was intended or likely to happen. If the party of whom surety was demanding refused to post surety, he'd be forbidden from carrying a weapon in public absent special need. Many jurisdictions codify this tradition either before ratification or shortly thereafter. DU Guy wants you there in South Carolina? Yeah, DUI Guy had reached out to me about potentially me coming to South Carolina. But I don't know that I want to make the trip at this point. I don't think it's a good expenditure of my time. In this particular case, the surety laws come closer to being relevantly similar to G8 than dangerousness and going armed laws discussed above. First, they're more clearly a part of tradition of firearms regulation, and they are comparably justified in that they were meant to protect an identified person from risk of harm posed by another individual. A Capitan says, I don't think it's bad to get exposure on other channels. I'm not saying it's bad. I'm just saying I don't think it's possible. I think at this point that I'm not sure how much more exposure I could get from appearing on channels. Like everyone, I'm not sure how much more exposure there is to get. But I might drop by Nick Rekieta's stream at some point and try to do it that way. Aspects of how the surety laws worked resemble certain of the mechanics of G8 as well. The surety laws required only a civil proceeding, not a criminal proceeding. The credible threat finding required to trigger G8's prohibition on possession of weapons echoes the showing that was required to justify posting a surety to avoid forfeiture. But that's where the analogy breaks down. As the government acknowledges, historical surety laws did not prohibit public carry, much less possession of weapons, so long as they posted the surety. When the surety laws imposed a conditional partial restriction on the Second Amendment right, G8 works in absolute deprivation of the right, not only of public carry, but possession of firearm upon any sufficient order. I think what I'm going to do instead is probably record something offline that redistills this discussion into a much smaller format and then edit it with some, suitable B-roll and stuff and go from there. I think is how I might do this. The government fails to demonstrate that G8's restriction of the Second Amendment right fits within our nation's historical tradition of firearms regulation. The government's proffered analogs falter under one or both of the metrics the Supreme Court articulated in Bruin as the baseline for measuring relatively similar analogs. How and why the regulations burden a law-abiding citizen's right to armed self-defense. As a result, G8 falls outside the class of firearm regulations countenanced by the Second Amendment. Doubtless, G8 embodies salutary policy goals meant to protect vulnerable. Weighing those policy goals merits this sort of means and scrutiny our prior precedent indulged, we previously concluded that societal benefits outweighed its burden. But Bruin forecloses any such analysis in favor of historical analog inquiry into the scope of the burden right. Through that lens, we conclude that G8's ban on possession is an outlier ancestors would not have accepted, therefore it's unconstitutional. I'm not sure if I 100% agree with that conclusion given their own description of the precedent, but I haven't been thinking about it very long, so I don't know. But I'm a little bit skeptical of some of the stuff. And then there's a brief concurring opinion. The right to keep and bear arms has long been recognized as a fundamental civil rights. Blackstone saw it essential to the natural right of Englishmen of self-preservation and defense. But the Second Amendment has too often been denigrated as a second-class right. That much for sure is true. In response, the Supreme Court has called on judges to be more faithful guardians of the text and original meaning of the Second Amendment. Our court today dutifully follows the framework recently set forth in New York State Rifle. It recognizes the absence of relevant historical analogs required to support the government's position. I'm pleased to concur. I write separately to point out that our founding fathers believed in the fundamental role of government to protect citizens against violence, as well as the individual right to keep and bear arms. And those two principles are not inconsistent, but entirely compatible. Our founders understood those who commit or threaten violence against innocent, law-abiding citizens may be arrested, convicted, and incarcerated. They knew that arrest and incarceration naturally entails the loss of a wide range of liberties, including loss of access to arms. So when the government detains and thereby disarms a member of our community, it must do so consistent with fundamental protections our Constitution affords those accused of crime. For example, the government may detain dangerous criminals, not just after conviction, but also before trial. Pre-trial detention is expressly contemplated by the excessive bail clause and speedy trial clause, and no doubt plays a significant role in protecting innocent citizens against violence. Our laws also contemplate the incarceration of those who criminally threaten but have not yet committed violence. After all, to the victim, such actions are not only life-threatening, they're also life-altering. In sum, our founders envision a nation in which both citizens and sovereigns alike play important roles in protecting the individual. Our decision today is consistent, and I concur. That's pretty good stuff. So, I don't know. I'd have to spend a little bit more time going through and thinking through the analogies. The explanation, at least to me, seemed a little bit off or a little bit like not quite right in some way. But, I don't know for sure. It just seemed a little bit, it seemed like there was a point of attack in there somewhere that maybe the rationale or maybe the reasoning was a little bit supporting its own conclusion. That isn't to say that I'm disagreeing with it. I'm just saying that I think that there was something in there that was a little bit unsatisfying. And I'd want to read through it a little bit more and think about it a little bit more to find out if I really agreed or not. It's like something in this is not quite flowing for me. And I'd want to read a little bit more. But that's what I think about the thing. So very, very exciting. Very, very exciting. Oh, Lord. All right. I definitely for sure need a break at this point. I for sure need a break, possibly a shower. You have to register a drone. Imagine the hoops for an F-15. That's funny. But we will be back with more. There was a Fifth Circuit case dealing with a guy who was found with marijuana in his car, apparently, and we'll cover that at some later point, maybe tomorrow. And now I'm bleeding. Way to go, Kurt. That's just great. Way to go, champ. So I'm gonna sign off for now. If you've enjoyed the stream, please remember to like it, do all the YouTubey things, like, comment, subscribe, all the rest of it. It's only because of you guys that I keep doing this and keep trying to make it work. I want to produce the best content I can for you guys. So keep going. And all the rest of it, I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends. Goodbye.